What's up, everybody? It's Jason Cruz here once again with another episode of the Legal Submission. As always, when I start these episodes, I remind you to like, subscribe, visit MMApayout.com for all your needs in combat sports, business, and legal information. And as we do all the time in the legal submission, we discuss a lawsuit either in the UFC, Bellator, the world of MMA. But this time, and it looks like we're having a trend here, boxing takes prevalence here at the legal submission. We have a lawsuit filed in Los Angeles Superior Court earlier this month, August, by broadcaster Mark Ortega. He's currently, according to his bio on Twitter, he's an editorial consultant for Fox NFL Sunday. He's done stuff in the past in the combat sports world, and he has filed a lawsuit against Ring City USA. As you recall, prior to the pandemic, Ring City USA was an up-and-coming boxing company, and they were putting on shows without affiliation to any without affiliation to any sanctioning bodies, and they had a good thing going before the pandemic happened, and unfortunately they have not had any other shows since 2020, I believe. You could correct me on that, but probably 2020. And the lawsuit stems from unpaid wages. Ortega claims that Ring City has not provided him as part of his work with the company. So turning to the lawsuit, which was actually filed in Los Angeles City Court on August the 5th, Ortega sued Ring City USA along with other entities and individuals that are associated with Ring City USA. He was hired, I believe, according to the complaint, as a researcher and content producer from November 2020 to December 31st of 2021. He was paid pretty good by Ring City USA to do these things. They agreed upon a payment plan in which he was actually going to be paid $100,000 a year, or what it broke down to $8,333,000 and some odd change per month to do these to work for Ring City USA. He also was able to incur expenses and be reimbursed by Ring City USA. And started to work for Ring City USA starting in 2021, and he was being paid by the company. He incurred reasonable and necessary expenses according to the complaint, and this relates to travel, food, things of that nature. I believe COVID tests as well. He had to pay for himself and was going to get reimbursed as well. Now, in the spring of 2021, Ring City USA started to default on payments according to Ortega's complaint. According to the complaint, on June 18, 2021, defendants paid plaintiff $8,333.33 via Fedwire credit to his bank. On June 24, 2021, they paid the same amount to his bank, but then they failed to pay him for wages until October 1st, 2021. So according to the complaint, he was paid through January through April 30th, 2021 for his services and wasn't paid for the rest of the year. The issue that occurred here was that there was an unauthorized signature of Ortega on the signature page of the confidentiality agreement that was drafted up by Ring City USA. Ortega did not sign the confidentiality agreement according to Ortega's complaint. And he attaches the agreement to the complaint to show that and assert that the signature on the confidentiality agreement was not his. He did not agree to the presented confidentiality agreement according to the complaint, and the defendants insisted that the further confidentiality language be added to the settlement agreement. So they did still, despite the fact that Ortega disputed that his signature was on the settlement confidentiality agreement and settlement agreement, they still attempted to negotiate the settlement in good faith, trying to avoid the lawsuit, and they looked into the possibility of presenting a confidentiality agreement. Plaintiff Ortega agreed that additional confidentiality language could be negotiated and added to the party's settlement. So what happened next? Well, on July 22nd, 2022, the parties agreed to a negotiated settlement and a confidentiality agreement for the unpaid wages for Ortega. So the parties had agreed. So what happened? Well, why are we talking about this now? Well, according to Ortega's complaint, Ring City LLC breached the settlement agreement due to a failure of consideration. And what does that mean? First of all, Ortega agreed to be paid for the rest of his wages, the $46,000 that he claimed was, and I believe as well as the expenditures he incurred. The agreement was it was going to be paid in two separate payments of $25,000. $12,500 would be paid in one installment, and another $12,500 would be paid in another installment. So defendants failed to make the first payment on July 22nd, 2022 when they agreed upon the settlement agreement. And on Monday, so July 22nd, 2022 was a Friday. On Monday, July 25th, 2022, plaintiff's counsel for Ortega contacted Ring City USA's counsel and asked, what's up? Why didn't they receive the first initial installment of the settlement amount? Well, it appears as though once prompted, they did receive a transfer of money for the first amount of the settlement agreement, $12,500. Now, the second installment was due 10 days after the settlement agreement was secured. So 10 days after, I believe, July 22nd, which was August 1st, 2022. So we are very recent here. On Monday, according to the complaint, on Monday, August 1, 2022, plaintiff and his counsel did not receive any payments from defendant for the second installment of the settlement agreement, for the settlement amount, That day, plaintiff's counsel attempted to contact defendant's counsel regarding the second payment, but did not receive any return communication that day. On Tuesday, August 2nd, 2022, at 5 a.m. Pacific, plaintiff's counsel sent defendants and their counsel a notice of breach and demand to cure letter via email. Now, these types of things in contracts, you see a notice of breach and demand to cure. Basically, it's one side who believes that the contract has been breached, notifies the other side that they believe there's something breached, there's been a breach. You have X amount of days to cure this before they proceed with alternative means, which is usually a lawsuit. So basically, the plaintiff's counsel is demanding that they pay the amount, the second installment of the settlement agreement, $12,500. Well, what happened then on August 2nd, defendant's counsel emailed Ortega's lawyer in response, and which is framed as a repudiation letter. A repudiation letter in contract law relates just to a notice that one side is notifying the other side that they are not going through with the contract. They are repudiating the contract. Big words, but basically that's what it was. And the reason why, and usually in the repudiation, they give you a reason why they're not going through the contract. The reason why is that they believe that plaintiff had allegedly breached the confidentiality and non-disparagement provisions of the settlement agreement. In the settlement agreement, apparently there were certain sections which Ortega was supposed to keep confidential, and also in non-disparagement agreements. I haven't seen the non-disparagement agreement, but non-disparagement agreements in general relate to basically stating that, hey, you're not going to drag the name of the person you're selling with. You're not going to say anything bad. You're not going to go on social media and tell everybody that you're, the guy, that they suck or anything disparaging like that. So basically, when a party settles, usually they want to make sure that there is nothing bad happening or tarnishing the name if they are to settle with the other side. Here, Ring City believes that Ortega did something to breach that agreement and therefore did not pay the $12,500 second payment. So plaintiff's counsel did respond to that letter of repudiation and stating that Ortega denies that he ever did anything to breach the settlement agreement. So he didn't breach any confidential issues or didn't disparage Ring City USA. But due to defendants' clear statement that defendants would not be making the second installment of the settlement amount after plaintiff's demand for performance, the settlement agreement was terminated due to a failure of consideration caused by defendants' failure to pay the entitlement settlement amount. In contract law, there's offer and acceptance, consideration for the acceptance, and agreement. So what's happening here is that Ortega's lawyer is stating that Ortega didn't breach the contract, and therefore the lack of consideration, the second installment of the $12,500, was not going through. Therefore, the settlement agreement is null and void. So basically he's stating that the settlement is off. We're not doing it. We're not doing it because you failed to go through with the consideration that we were accepting at the particular time. So the lawsuit was actually filed really quickly because on Wednesday, August 3rd, plaintiffs and defendants counsel conferred with what had occurred and basically stating, hey, we were close to the settlement, but they asserted their positions. And August 5th, on Wednesday, the plaintiffs' counsel were talking. On Friday, lawsuit occurred. So that's where we stand right now. Obviously, Ring City USA has an opportunity to respond in either filing a motion to dismiss the lawsuit or answering the lawsuit or doing something else, maybe settling now, who knows. But basically, we will see what arguments Ring City USA will have as far as what did Ortega do to breach the settlement. Obviously, he denies it, but we will see what Ring City USA does. This is obviously the causes of action here relate to California labor law. Obviously, they sue under failure to pay wages, a breach of contract, waiting time penalties, failure to furnish timely and accurate itemized wage statements, unfair business practices under the California law, fraud because of the alleged forged signatures, and rescission of the contract. So not breach of, breach of contract as well. So he's asking at this point for compensatory damages of at least $18,149.49, which represent wage, reimbursable, reasonable, and necessary expenses related to plaintiff's job duties. Penalties under the labor code, because they believe that Ring City USA committed some penalties, $11,538.49, an award of damages and penalties to plaintiffs for defendants' failure to provide accurate itemized wage statements pursuant to the California Labor Code, and restitution due to defendants' unlawful business practices, as well as your good old reasonable attorney's fees for bringing the lawsuit. We will see what happens with this lawsuit. Obviously, not being paid by your employer really sucks. It's terrible. But does Ring City USA have actionable arguments related to the fact that whether or not Ortega said did breach their contract or the settlement agreement? So should Ring City USA really pay him the $12,500? Problem is now there's a bigger issue involved because you gotta get the lawyers involved, and now there's assertions of penalties according to the California Labor Code, and now it's becoming a bigger thing than the actual $25,000 which Ortega had agreed to settle the amount. So now the settlement amount is not going to be $25,000 or the $12,500 that Ortega needed back. It's going to be much more, and we will see how Ring City USA will defend this. Once again, this is Jason Cruz with MMA Payout, the legal submission. Once again, please like, subscribe, do what you can. Have a great day, and we'll see you next time. Bye-bye.